Okay. Welcome everybody to this H3D Foundation webinar. I'm Nicola Elliott-Wong and it's my great pleasure to host these sessions. Today, we're super excited to have LifeArc with us. LifeArc is, as many of you know, a huge collaborator and supporter of our work on the continent. And we're very honored to have IP specialists from LifeArc join us for this very important webinar. This webinar has actually come out of a request, an ask from one of our GC Ada flagship projects. And we had some discussions and workshopping sessions were held internally. And we said, gosh, please can we extend this to our broader network? We are so grateful to have LifeArc representation join us to do just that. So I'm going to introduce our speakers now, and then we'll dive straight into the webinar. Okay, so we've got Svetlana Gracheva with us, the head of IP at LifeArc. Svetlana is the head of intellectual property at LifeArc, where she leads IP strategy, diligence, and governance across translational research, grant funding, and investment activities. She has extensive experience in IP management, licensing, and commercialization within the life sciences and advanced technology sectors. Previously, Svetlana was Senior Director of IP at Oxford Biomedica, a leading cell and gene therapy CDMO, and earlier served as the head of IP at Oxus Energy, which established and led the IP function. Svetlana holds a PhD in chemistry, a master's degree in chemical research, and a postgraduate qualification in intellectual property law. She is a member of the Bioindustry Association, BIA, IP Advisory Committee. Thanks for being with us, Svetlana. We're very honored to have you today. Co-presenting with her is Sweta Lee, also from LifeArc, as the Senior IP Manager of LifeArc. Sweta Lee is the Senior IP Manager at LifeArc with extensive experience in IP strategy and due diligence across pharmaceuticals, biotechnology, and translational research. Prior to joining LifeArc, Sweta worked with the Medical Research Council, IEN commercialization portfolio, and within the National Institute for Health and Care Research, IP unit, where she supported the management and protection of publicly funded research outputs and helped ensure equitable access considerations, including for low and middle income countries. Her career includes roles in pharmaceutical and biotechnology companies such as Oxford Biomedica and Taylor Pharmaceutical Industries, as well as consultancy positions delivering IP search and analysis services. This breadth of experience gives her a well-rounded perspective on IP from both strategic and operational viewpoints. Sweta holds a master's degree in chemical engineering and biotechnology from Manchester University and a postgraduate qualification. Thank you, Sweta, also for being with us today. In the background as well is Callie Hall, who many of you know, who might give a few words at the end of the session. And really, again, what this is about is trying to bring this knowledge into our kind of academic space. Many of us on the call today and in our network are working in academic institutions where some of this thinking hasn't formally properly matured to where it needs to be for our drug discovery work and pipeline. So that's really what this is about. And I hope you're all going to just absolutely absorb it and pop all your questions into the chat and have a robust conversation at the end. Because of the two speakers today, it's a slightly longer presentation. And so we imagine we'll get through the presentation within the hour and then have about 15 minutes afterwards for questions. So feel free to note your questions down or populate the chat. I'm going to hand over to our speakers now. Thank you so much for doing this, and I'll be in the background if anything is needed.
Thank you so much for inviting us. It's a great pleasure to be able to share the knowledge, and we are all very passionate about IP and what we're doing at LifeArc. And yeah, thank you so much for inviting us. So why IP is important? You can get a market share when you have protected your intellectual property. It gives you a competitive advantage. You can exclude others by patenting your invention. You can use it as a bargaining tool. When you have some intellectual property, you can bargain it with your competitors, for example. It attracts investments and customers, and you can manage it the same way you manage property, because it can be sold, it can be mortgaged, it can be licensed, it can create revenue. But what is also important when you work in life science and you develop therapies for patients, this requires extensive investment. And Big Pharma says that 75% of investment is actually taking the medicine through clinical trials. So it's substantial. It can go up to 2 billion to take a product on the market for Big Pharma. So obviously, to attract that investment from Big Pharma, they're looking for projects which have a strong IP protection, because they need a return of investment. So when we talk about intellectual property rights, very often, and when we talk to academics, they say we don't have any intellectual property. What they mean, we haven't patented that innovation. But essentially, intellectual property rights is a very broad area of law, and there are many different rights you can have. Apart from patents, there is a copyright, and this copyright in computer software is protected by copyright. There are trademarks, business name, domain names. There are rights and designs. And actually, strictly speaking, confidential information is not an IP right, but if you work with agreements and you draft agreements, you might notice that the definition of intellectual property goes quite broader than just pure IP rights from law. It covers confidential information and the rights to protect confidentiality. And confidential information can be extremely broad. So it's all technical information, it's all SOPs, it's assays, it's you got during your project. So when you worked on a project, and even if you don't have any patent protection, you do possess very valuable information, and it's in itself has lots of value. So it's important to when you work on a project to know what you created and have a records of what you created, and especially when you work on collaboration, have very clear who done it and when done it. Accurate records are quite important when you work, especially collaboratively. So patents. In life science, patents are very important. And what is a patent? Patent is essentially a document which is issued by a government or a super government office like European Patent Office. And it's a limited right, time-limited right, to exclude others from using an invention, but only as described and claimed as a document. It's very important. It's a negative right. You can exclude others, but it doesn't mean you can yourself practice your invention. Usually patents last for 20 years from a filing day on, and you have to pay renewal fees to keep it alive. And for pharmaceutical inventions, the term are extended by up to 5 years. You can apply for patent term extension in the US or supplementary protection certificate in Europe. So how do you get a patent? First, you need to prepare a patent specification. Then you file a patent specification at the patent office, usually in the patent office in the country where you reside. Depends on which country you are. There are different laws and formalities. Then patent application undergoing search and examination at the patent office. It's published 18 months. You usually then enter what we call prosecution. So essentially it's arguing with examiners that your invention is novel and inventive and complies with all national laws, and eventually your patent is granted. So this is a timeline, how the whole patenting process works. So your first application, and we show that LifeArc is based in the UK, so we would file in UK Patent Office, and this will be called a priority application, and this starts the clock. So after that date, no one else can apply for the same invention. So our now system almost uniquely, it's first to file. So the person who files first will be entitled for this invention. So if your competition invented exactly the same thing, they will, after you, they will not get their patent protection for their invention. So, and this first year is very important. It's called a priority year. And during this year, you still can top up your application with additional data. And at 12 months, you can make a decision how you want to progress with your invention. You can, at this point, file at national offices, or you can go what we call PCT route. So it is majority of countries, industrial countries, are members of Patent Cooperation Treaty. So it allows you to file almost like word patent, which will be pending until 30 months since original filing. From priority day, 30 or 31 months, and you can use this time to decide in which national countries you need protection. Or a lot of academic institutions use this time to find a commercial partner, out-license it. And at 18 months, this important date, because at 18 months your invention, your application will be published, so it's made public. Before 18 months, you can still withdraw it and it will stay confidential. It can happen for any reason, commercial reason. International Patent Office will give you search report. If search report is not favorable, you might decide to withdraw and refile later, for example, when you have more data. But at 18 months, everyone will know about the invention. And at 30 or 31 months, depending on the country, you have to decide in which countries you want to file your applications. And we show like major jurisdiction: Europe, Japan, China, US. And each country has its own national laws. So your application will be examined under these national laws. And eventually, you have to argue with each patent office about your invention, and eventually it gets granted. In Europe, then you have a choice. You can file validated in all member states of European Patent Convention, or now you can choose unitary patent. And 20 years from filing date, not from priority date. It's very important. So it's usually PCT filing date. Your patent will expire, subject to paying fees. So patents are very different from publications, because their main role is to protect your inventions. The most important bit in a patent document is claims. They usually at the back of a patent application, this numbered paragraphs which define the scope of your protection. The rest of the document serves the purpose to support your claims. So you have to have a description which should be enabling, so people who are reading this patent can repeat your invention and know how to practice it. Abstract is used for searching, and there are drawings also. Sometimes there are, sometimes there are not, but it also, the purpose is to explain the claims and how to interpret the claims. Requirements for patentability is in Europe, it's sufficient disclosure. So your invention needs to be sufficiently disclosed for a person skilled in the art to be able to practice your invention. It should be new. It should be not obvious. So obvious modifications are not allowed. So in Europe, it's the test is problem decision approach, what problem your invention solves and what is the decision and whether it's obvious. It has to be industrially, it has industrial application, and there are excluded categories in Europe. So moral, for example, use of human embryos in Europe, methods of diagnostic and treatments also are not allowed. So you need to, when you prepare patent specification, it's very important to spend a lot of time on making sure that your specification complies with the requirements, whether it's novel. And there are many ways you can destroy your novelty. It's either by oral disclosure, or, for example, if you have a novel compound and you give it someone without confidentiality agreement or material transfer agreement, it will be also disclosure. And also looking at what already in the prior art, and my colleague will talk about it a bit more details later. However, when you look, it's for other people patents, it's important to understand that not every application will be granted. Everyone can apply for a patent. You just write a specification and you pay the fees and you can get it published. But it doesn't mean it will be granted at the end. And we give here an example where someone applied for a process of reincarnation. It has one claim, the process of reincarnation and rebirth, which results of immortality. But they don't give any technical information how this can be achieved. So this application never will be granted. We come across a lot of claims which will never be granted because they either not supported or they too broad and they attract a lot of power. And this is more reasonable example where it's antibody claim, it's application. So when you review patent applications, come across patent applications, it's important to know that application usually will have letter A at the end. It means it hasn't been granted yet. And usually claims of applications are broader. And once they get through prosecution, they get narrowed. So, and the way they get narrowed is they usually you put additional features into claim one. So when you draft your patent application, you need to ensure you have a lot of fallback positions, and you list all possible features which can be used in your invention. And generally, the shorter the claim, the broader the claim. The more features it includes, the more narrow the claim is. So we also, when you work about on a project and you're developing new therapies, it's important to understand patentability versus freedom to operate. So, and sometimes people get confused about these two terms. Patentability is whether your invention is meets patentability criteria such as novelty, inventive steps, sufficient disclosure, industrial applicability. So let's imagine you invented a rocking chair, and there was no rocking chairs before, so it's novel and inventive. But someone already have a patent for a chair. So even though your invention is novel and inventive and you have a patent for it, it doesn't mean you can practice it without infringing broader patent for a chair. So freedom to operate means that you can have freedom to make, use, sell, or distribute product or service without infringing third-party rights. So when you're in this situation, you have option, you either take a license, which is quite usual option, or you design around, so your patent is no longer a problem for you. You can wait for the patent to expire and then launch your product, or you can look at validity, because very often patent offices, when they examine patent applications, they can miss some key piece of prior art, and you can attack validity of a patent. In European Patent Office, there is actually a procedure called opposition. 9 months after the patent been granted, you have opportunity to oppose grant of this patent and put your arguments forward, especially if you have a good prior art to argue your case. So when we design and think about IP strategy is always there to support business strategy. So it's sometimes people think the IP strategy is something quite complex, but essentially it's quite simple. If your company makes planes, you don't file patents for kettles, for example. So IP strategy is needs to support your business goal. So when people come to me and ask how we should split IP rights, how we should who should own IP rights, and who should control IP rights in any certain collaboration, I always ask, what is your end goal? What do you want to achieve at the end? Because if you want, for example, to out-license it to Big Pharma at the end, you probably need to decide who will lead those out-licensing effort, and probably this entity who will be trying to find a commercial partner should have a control over patent rights. And here you can see 2 examples of how companies work on design their IP strategy. For example, cell and gene therapy CDMO, they owned vector technologies, platform technologies, and they essentially offer their services to use the vector technologies to clients. And what is important for them is that any improvements to that vector technologies belong to them. So when they enter any collaborations, they say we retain ownership and any improvements to the platform, but your specific IP belongs to client. And it ensures that both parties are happy. So company continues to practice their platform technology and owns all improvements and have freedom to offer to other clients. And client retains the IP specific for their product. And the same second example when a company developed, a battery company developed a new electrode material, worked with chemical company. So they developed the electrode together. And instead of joint ownership, they just filed on their specific technology. Chemical company filed on material and battery company filed on electrons. So, and they've done it on the same day. So none of the patent is a prior art, but essentially they have a freedom to use their own inventions independently on each other.
Thank you very much, Svetlana. So I'm going to be talking about IP searching next and how it can help shape your project and potential IP filings. And of course, thank you for attending and giving us the opportunity to speak today. So searching can really help maximize strength of IP as it makes you aware of what is going on in the field. By looking to see what is in the public domain, you will be aware of competitor patent filings. Although, as Svetlana mentioned, note that patent applications do not publish for 18 months. So this creates a gap in what may have been filed and what can be known. So it's not just patent literature, but non-patent literature, such as publications, oral presentations, posters, etc., that can also count as prior art, which Svetlana also mentioned. So prior art, just to give you a definition, is any public information that existed before a patent application's filing date. And it can affect whether an invention is considered novel and patentable. So that's anything in the public domain can count. So by knowing what is there, you can know if your invention is still novel and inventive to be able to file a patent on, or if you need to consider prior art to differentiate your project to make it novel and inventive. So by searching, you can make sure what you are filing on has claims which are considered novel and inventive, thus saving time and costs in the long run. Now, just to note that some jurisdictions, such as South Africa, do not provide a search. So it is important to be aware of what could be found by other patent offices that do search and examine during prosecution. So the type of search depends on the stage of your project. At the beginning of a project, you may want to review the landscape to see what others are doing in the field more generally. Say you have an idea, but are looking to see which direction to develop the idea in. This sort of search can tell you what other people have done. Then, as your invention becomes more focused, you can target the prior art more to see what exists in the prior art and do a prior art search in a more focused way. And a patentability search would be carried out when you have an idea of what your claims may say to see if they are novel and inventive. An FTO search, so freedom to operate search, would be to see if you can launch a product without infringing on other third-party IP rights. And finally, a validity search would be done if you want to see if a third-party patent is actually valid. Say, if you find you could fall within the scope of their claims, you may want to see if the patent is valid. So search methodology is important. First of all, you need to define the scope of your search so that you don't end up going down a rabbit hole and you keep it focused. Building a robust strategy is key to a search, because basically if a patent family isn't picked up by your strategies used, you're not going to find it. Now, then once you've got your strategy, you've got a list of patent families to look through. You can analyze those patent families and determine relevance to your project, and determine relevance depending on the type of search you are conducting. And then typically at LifeArc, we would index those patent families into various categories. For example, if we're looking at a pharmaceutical product, we may index the families into use, formulation, methods of manufacture, combinations, and product patent families. And finally, it may be important to monitor and update the searches as time goes on to see what is happening in the landscape or with a particular family of interest. So how do you build the strategy piece? So these bullet points sort of specify the things you may want to look at. Known assignees, so an assignee is, say, a company or organization that might have applied for a patent application, and inventors may have already filed in the field. So it could be a good way to see what they are doing. So just to note that I'm focusing on searching for patent information, because academics are very good at searching for non-patent information. So citations are a good way of seeing what patent offices or the applicants themselves have found. And note, you can look at forward citations to see who has cited the patent family in the future. So classifications are given to a patent family by patent offices, and are like an indexing system that the patent offices and people searching for patent families use to help them find things more easily. Now, classifications can be used in combination with each other, or they can be used on their own if there are not too many hits in a particular classification. And we'll look at examples of classifications in the coming slides. Classifications can also be used with keywords. Now, keywords can be an important element when you're building your strategy. You will use keywords when looking for publications, for example, and they can be used in a similar way to find patent families. Now, you must consider spelling variations, such as US spelling versus UK spelling, for example, spaces or words order for particular terminology, and of course any synonyms and all terminology that could be used in a patent application so that you can pick it up. Now, if you've got sequences, for example, an antibody you're developing, you can do sequence searching online. And similarly with small molecules, you can do chemical structure searching. So it can be important to have your structure to see what other people have done in that, that could be related to the structure or sequences. So just to focus on classifications a bit more, so two main classifications that are used certainly by me and our team at LifeArc are the cooperative patent classification and the international patent classification. So the IPC is used by more than 100 patent offices worldwide, so it's quite broad covering. The CPC is a joint classification system by the USPTO and the EPO, and is used by more than 45 patent offices worldwide. So the CPC is essentially based on the IPC and is commonly used for searching territories such as the US or Europe, as the patents are indexed further than the IPC in general. So you may potentially be able to target your subject matter in a more focused way. Now, just for information purposes, for Japanese patents, the Japanese file index and file forming term system exists and is based on the IPC. Now, that's just for awareness that other classification systems exist. Now, here I've got a picture on the slide showing Espasnet. So Espasnet, you can search for Espasnet online, and it's a search tool by the European Patent Office. And when you go onto Espasnet, you can do a classification search by clicking here, and it will bring up all the different classifications that you can look into. So here are some classification examples. Now, this first slide, I have sort of indexed it in a way that you can combine these classifications. Say you were looking for an antibody, that's your development, and say you were targeting EGFR. So here you have a classification for an antibody, and you can combine that in your search with the classification for EGFR, really to focus in a classification way without using keywords to target your search. So I've got further examples here that might be more suited to a global health setting. So here is a classification, A61P31, for anti-infectives, and you can see that they are indexed further and more narrowly. So if you were looking for, say, TB anti-infectives, you would look at this classification here, possibly combine it with key terms or other classifications depending on your project. But these are just examples. So we've got a further example here of YO2A50, human health protection, and YO2A50/30 is against vector-borne diseases. So if you were looking at this field, you might want to consider this classification in your strategy. And a final slide just to show something that is away from A61 or Y. In the chemistry classification, C12, we have C12Q1, measuring or testing processes. And you can see down here, /689 is for bacteria specifically, with the above classifications that also may be relevant to your project to build on that strategy piece. Now, where do you search for patents? So here are a few links that can be accessed for free as to where to find relevant patent families. So you can use the European Patent Office site called Espasnet, the first link here. Google Patents is an easy to use tool for a first look. The US Patent and Trademark Office holds all published US patents, and they can be found on this link. WIPO, so that is the World Intellectual Property Organization, has lots of training materials, as well as the EPO website, lots of training materials there that you can go and look for lots of free resources that are available to further your education in IP. So just to note, individual patent offices also have freely accessible databases. Now you've got Depotisnet for Germany, OzPat for Australia, the UK IPO for the UK, and many other international patent offices will have these free databases for patents in those countries for you to go and have a look. So how do you use Espasnet? So first of all, you would go to the Espasnet website, and here you will see you can click on advanced search, or you can enter your search terms here. if you want to really build a strategy based on classifications, key terms, or applicants, citations, you can click on advanced search and you will bring up, this is advanced search form, where you can click on the various aspects to target what you want to search. Usually I would search title, abstract, or claims, and you can and fields together or all fields together. So you can really build your search strategy here, and then Espasnet will retrieve a number of hits that you can then analyze and determine relevance for your project. So next, I hand over to Svetlana to talk about avoiding common pitfalls.
Thank you. And I would like to explain a little bit why we'll spend so much time on explaining how to search. Patenting, as you might know, becomes quite expensive, especially when you go to and want to file broadly in national offices. So, and the whole prosecution process, when you argue with examiners, and each national office will do their own search. If you do search at the point when you prepare your specification and you find prior art, you can draft your specification in such way that you can explain why your invention is novel and inventive over the prior art. If you don't do preparation, and in national prosecution, patent office finds prior art which might be very close to your invention unexpectedly, and you don't have any basis in your specification to amend it. Especially in Europe, it's very strict. They don't allow you to add anything extra to the specification after it was filed. So it might be a very costly mistake not to do this homework before you file. The more homework you do, the less money you will spend in a long time prosecuting this. And another common pitfalls, especially we see it a lot in academic collaborations when people say, we work together and we own everything together. Because we don't know what IP we will create and who should own it, and we don't want to spend a lot of time on drafting agreements. We just want to work, but essentially joint IP can create a lot of problems down the line. So joint IP is when property is owned by two parties. And as we talked before, intellectual property laws are national laws. So if you don't specify in agreement how you manage your joint IP, it will be subject to national laws, and they are very different in different jurisdictions. And the rights of joint owners are very different in different jurisdictions. But also different types of IP managed different in different jurisdictions. So it becomes really, really complex later down the line. And one example, very often, for example, in US, joint owners are free to out-license their patent application without consulting each other. So you might end up in a situation when you own jointly a patent with another party and they out-license it to your competition and they don't have to consult you. Whereas in UK, you cannot out-license your invention without an agreement with the second owner, and sometimes that agreement is difficult to reach, relationship might break up, and it creates a lot of challenges. Essentially, it means no party have single control, and it's and no decision-making process might become very long. and you might have delays because of this. Parties, when initially they might have a common goal, as time goes, they might drift apart and there might be conflicts. And essentially, it lacks, creates delays. And in my practice, I've seen when even if parties, especially in academic environment, are willing to work together, reaching an agreement, and TTO offices understaffed. The process is slow, and putting agreement after the work is done takes such a long time. And the longer time you take before you reach an agreement, who owns invention essentially delays your filing, your competition can beat you to it. So it's really worse before you enter collaboration, think about how you split IP rights. And as I said, it requires consent from all the owners, depending on what you want to do. You might not reach agreement of a term. You can risk that it will prevent commercialization, and it's especially difficult in biotechnology market. However, if you decide that joint ownership in collaboration is something strategy you're going for, make sure that when agreement is drafted, you talk about how you pay for it, how you make decision, who is in control of prosecution, who will make decisions on enforcement, and who will be leading commercialization efforts, and all of this. The more details you have in agreement, the better it will be working down the line. Publication. The publication strategy is very important because, as we mentioned earlier, invention is only new if it doesn't form part of state of the art. And state of the art is actually everything that's made available to public. And it can be oral disclosure in a conference, it can be publication in a paper. There have been instances when academic advertised PhD project and say detection of X using Y, and it is a disclosure. So everything you put out there for public, and even if you put it very quickly on the internet and remove seconds later, it's all discoverable now with a time machine and everything. But also anything, as I said, giving samples to someone without a confidentiality agreement, even if you didn't tell them the structure, it's public disclosure, because patent offices take a view that people can easily analyze your compound, and if there is no confidentiality agreement, they are free to do so. So you can really destroy your invention by disclosing. And usually universities, and here at LifeArc, we have a publication process where we review all publications before they become public, so we protect our IP assets. Also, there is a common sort of a misunderstanding. If you file your application, you are now very free to publish, but we also say be very cautious. Even if you file your patent application, your publication can still harm your patent, because you still have this 1 year priority when you, first of all, you can add new experimental data. And if this data bring new information, or how we call it, new subject matter, it means that this new information is not entitled to a priority date. And then if you publish straight after you file, your own publication becomes prior art against this new subject matter you added. And chances are this new subject matter will be obvious in the view of your own publication. So be very conscious whether if you're still working on this invention in the first year, it's probably better to delay publication. Another thing which your publication can, as I said, for any reason you might consider to withdraw and not to continue with your patent application. However, if you published it, you can no longer refile it and restart the clock, so you have to continue. So when you file your patent application and you go for publication, be very sure that you will continue this patent application and you will not be in a station and you have to withdraw and refile. But even after your application is published at 18 months, be very mindful what you put in your publication on your invention, but you cannot contradict any conclusions which you made in your patent specification, because if ever your patent be challenged, those contradictions will be used to invalidate your patent. And there are some examples, for example, when academics put or inventors put invention and they exemplify using mouse model, and they claim medicine for treatment of something, and then they make a publication and say, we actually don't know how this mouse model translates into humans. This directly harms your patent application because essentially your invention is directed for treating humans. So be very mindful of what you put in publication post filing, and if you are not sure, contact your city office or your patent attorneys.
So just to summarize the talk, so an effective intellectual property strategy is a critical component in ensuring that innovations can successfully progress essentially from concept through development and to market, and ultimately the goal is always to deliver impact. So firstly, strategic alignment is essential. As Svetlana outlined, the IP strategy must be closely linked to the overarching business or organizational objectives, ensuring that the protection and use of IP directly supports those goals. And those goals could be anything such as patient impact, potential revenue generation, or partnership development. So without this alignment, IP can risk becoming a standalone activity rather than that driver of value creation that it can really bring potentially. So ownership and deal structure need to be clearly defined at the outset. This includes establishing explicit ownership of background IP, which exists prior to the project, foreground IP, which is generated during the project, and as mentioned, avoiding joint IP wherever possible is recommended because shared ownership can introduce complexity and potentially hinder efficient commercialization or impact, and we wouldn't want that to happen. So clear licensing terms and rights should be agreed early to enable streamlined decision-making. And the strength of protection is a fundamental consideration. So that involves evaluating whether the innovation meets the legal requirements, We've mentioned novelty and inventive step numerous times during this presentation, as well as assessing that existing prior art landscape, because strong patent protection should aim for those broad claims that cover multiple potential applications ideally, while including those fallback positions that provide defensibility if those primary claims are challenged for whatever reason. Freedom to operate must be carefully assessed to avoid infringing third-party rights. So identifying those potential IP barriers early can allow teams to proactively develop mitigation strategies, such as negotiating licenses or designing around existing patents. So another essential element of the IP strategy is that thorough understanding of the competitive landscape, which involves monitoring competitors, reviewing prior art, and tracking emerging technologies that could affect the asset's development or commercial potential. So by conducting those robust IP landscaping exercises, you might even be able to identify white spaces, so gaps in the technology, avoid duplication, and strategically position your assets for that value creation piece. So basically, allowing decision makers to anticipate risks and opportunities early can ensure competitiveness remains throughout the life cycle of your project. So effective portfolio management is important because it's not a one-time activity, but an ongoing process that requires careful planning and decision-making. So organizations must actively manage this patent life cycle, including, filing strategies, prosecution timelines, maintenance decisions. Cost might be a decision. Consideration of expiry risks is crucial to ensure that value is derived from patents and, maximized over the lifetime. So a strong, balanced portfolio is good if you can build that into your IP strategy, and obviously aligning that IP strategy with the commercial objectives. So making sure your IP is commercially relevant can ensure that your resources are allocated efficiently. And obviously, if your IP is commercially relevant, it means it can continue to support business growth and progression. And finally, a collaboration strategy might play a vital role in the IP management, as Svetlana's mentioned already, particularly in environments where partnerships and joint development activities might be common. So, that ownership must be clarified, and we cannot stress it enough to make sure future commercialization efforts are not hindered. So yes, licensing arrangements might work, and long-term commercial intent needs to be established with those well-structured agreements where each party's rights and responsibilities are understood to reduce the likelihood of disputes and enable smoother progression towards that market entry. So together, all these elements form a comprehensive framework that can safeguard your innovation, which is ultimately what we want the take-home message to be today, to basically enhance potential for successful development and investment, attraction and market entry, as the first slide indicated. So I'd like to say thank you very much for listening to us and attending, and thank you to the organisers for allowing us to speak today. I will pass over to Callie, I believe.